Jefferson County Court at Law number 2 is back in session. Court is in session in 2 cases. First case is cause number 324-644. Second case is cause number 324-648. Both cases are styled the state of Texas versus Colton Ray Goodman. Mr. Goodman, is that your full name?
Yes, sir.
Mr. Goodman, would you please raise your right hand? Mr. Goodman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Goodman, you may put your hand down. How are you doing, Mr. Goodman?
Well.
That's good. Now, Mr. Goodman, you're here represented by your attorney, Attorney David Grove. Attorney Grove, how are you doing?
I'm doing well, Judge. Thank you.
That's good. Mr. Goodman, in cause number 324-644, you were found guilty by a jury on August 27 of 2022 for the Class A misdemeanor offense of terroristic threat, family violence. And your attorney and yourself requested that the court would assess punishment. The court ordered a PSI report on that day, September 27 of 2022. And Mr. Grove, did you get a copy of that pre-sentence investigation report?
Yes, Your Honor, I did.
And did you review this document with your client?
Yes, sir. I reviewed it with Mr. Goodman and gave him a copy of the document itself. I reviewed it with him before.
Okay. Is there any corrections or deletions or additions that need to be made in that document?
No, Your Honor.
Okay. Mr. Johnson, did you receive a copy of the PSI report?
I did, Your Honor.
And did you get a chance to review it?
I did.
And are there any additions or the deletions that need to be made in the pre-sentence investigation report?
Not to my knowledge, Your Honor.
Okay, the court has received a copy of the pre-sentence investigation report in cause number 324-644, case of style state of Texas versus Colton Ray Goodman. The court has read this document, and the court will take judicial notice of the finding, conclusions, recommendations in this document. Now, in viewing the document, Mr. Goodman, I note, among other things, that the probation officer, the first thing that she basically said was that you took responsibility for your behaviors and admitted that you made a bad decision. Is that correct?
Yes, sir.
Okay. So, and I see also, Mr. Goodman, that your attorney and the state decided to come to an agreement as to what the punishment will be in this case. Is that correct, Mr. Grove?
Yes, Your Honor.
And is that correct, Mr. Johnson?
That's correct, Your Honor.
And just for the record, Mr. Grove, you are waiving a record in this case?
Yes, sir.
Okay.
Waiving the record.
And Mr. Johnson, what is the recommendation, the punishment recommendation in this case?
Your Honor, the punishment recommendation is 5 years jail.
Wait on.
5 years confinement in Jefferson County Jail.
You say 5 years?
I'm
Oh,
sorry. 5 days confinement in the Jefferson County Jail.
We'll agree with the latter one. The first one, that's more than the offense allowed, and I was pretty shocked.
that's why I say 5 years.
Yes, sir.
Yeah. Okay. Wait, hold on. Now, you just go on, you said it's 5 days?
5 days confinement in Jefferson County Jail, Your Honor, and we're asking that the court give defendant credit for the 5 days he previously spent in jail, making this a time served
Okay,
agreement.
okay.
Sentencing agreement.
So we don't need that. Okay, so, Mr. Grove, is that correct? That's the agreement?
Yes, sir, and to run concurrently with Mr. Goodman's other case, which is 324-648.
That's
Okay.
correct, Your Honor.
Is that correct? Now, Mr. Goodman, in this particular case, the state is offering that you serve 5 days in Jefferson County Jail. However, you will not serve any more time in Jefferson County Jail on this case because you've already served 5 days in Jefferson County Jail. Therefore, you'll be given credit for time served. Now, the court costs in this case which is $342, will be taxed and retired. That basically means that because you've already served 5 days in Jefferson County Jail, the 5 days has eaten up, has already paid off the court costs in this case. So you will not be required to pay the court costs. And that's why the court costs will be taxed and retired. Do you understand that? Okay, so that's the agreement. And now the court is going to follow the punishment agreement that has been agreed to by the state and the defense. And the court will run this case concurrent with the companion case, cause number 324648. And also, Mr. Grove, you have a copy of the trial court certification of defendant's right of appeal in this case? Should be on paper.
We signed one, Judge, but I think it was on the tablet. We could re-sign another one.
I thought we had gave it to you. I thought we had gave it to you on, they printed it off of the tablet. The certification, trial court certification of defendant's right of appeal. I gave it one off of, hold on a minute. Okay. Well,
Judge, we will get one if we do not have one.
matter of fact, here it is right here. You were supposed to make the correction. I think that first box shouldn't be, you needed some.
First box should be.
Here you go. Here you go.
Plea bargain is no
Here you
longer
go.
there.
Mr.
But
Grove, here you go. You could use this here to write it out if you need to. I gotta go. I already have it right. That was just a PSI. You just making the correction, right? You just whiten out the first box.
Yes, sir.
Okay, thank you. Now, Mr. Goodman, I have before me in clause number 324644, a document that is titled Trial Court's Certification of Defendant's Right of Appeal. Mr. Goodman, do you recognize this document?
Yes, I do, Your Honor.
And is this your signature on the line that is titled Defendant?
Yes, it is, Your Honor.
Now, Mr. Goodman, before you signed this document, did your attorney, Mr. Grove, go over this document with you?
Yes, it did, Your Honor.
And did you read everything in this document?
Yes, I did, Your Honor.
Now, also in this document, there's one box that's checked. The box says check. Well, first of all, yeah, the box that's checked at the top of this document states that that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Now, before you sign this document, did your attorney go over this document?
Yes.
And did you read the document?
Yes, it did.
And did you understand everything that your attorney went over?
Yes, it did.
And is everything in this document true and correct to the best of your knowledge?
Yes, it is.
All right. The court is going to sign. Okay, here you go. Okay, so now again, Mr. Goodman, did you understand the state's agreement in this case?
Yes, sir, Your Honor.
And do you think that it's fair and just?
Yes, it is, Your Honor.
And do you accept it?
Yes, I do, Your Honor.
Okay. I'll follow the punishment agreement that has the state as well as the defense has come to. In this case, Mr. Goodman, we will move to your agreement. We'll move to your next case. And the next case is cause number 324-648. The case is styled the State of Texas versus Colton Ray Goodman. Mr. Goodman, in this case, I have an information before me that has been filed by the Jefferson County District Attorney's Office. This information alleges that on or about October 12th of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of terroristic threat, family violence. Mr. Goodman, do you understand what you've been charged with?
Yes, I do.
And to this charge, Mr. Goodman, how do you plead? Guilty, not guilty, no contest?
No contest, Your Honor.
Now, you're pleading no contest freely and voluntarily?
Yes, sir, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, Your Honor.
Mr. Goodman, I also have before me a document that is titled misdemeanor plea admonishment. And before I get to this document, Mr. Grove, are you also waiving a record in this case as well?
Yes, Your Honor.
Okay. Now, Mr. Goodman, in cause number 324-648, I have before me a document that's titled misdemeanor plea admonishment. Mr. Goodman, do you recognize this document?
Yes, I do, Your Honor.
On page 2 of the same document, Mr. Goodman, there are a set of initials, CG, that are on the line next to a box that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes, I did, Your Honor.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, it is, Your Honor.
And on the next document that is titled trial court certification to defendant's right of appeal, do you recognize this document?
Yes, I do, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, it is, Your Honor.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, I do.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, I do.
And I also have a document, in this case, Mr. Goodman, that is titled discovery certification. Mr. Goodman, do you recognize this document?
Yes, I do.
And is this your signature on the line that's titled defendant?
Yes, it is, Your Honor.
And Mr. Goodman, before you sign and initial all of these documents that I've just mentioned to you, did your attorney, Mr. Grove, go over these documents with you?
Yes, he did, Your Honor.
And did you read and understand everything in these documents?
Yes, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, it is.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and I have State's Exhibit number 2, the probable cause affidavit that is in the court's file. State, would you like to offer State's Exhibit 1 and 2?
Yes, Your Honor. State offer stage 1 and stage 2.
No objection, Your Honor.
No objection. State's Exhibit 1 and 2 are admitted. Mr. Grove, you advised and counsel Mr. Goodman. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of.
Mr. Goodman, your attorney, Mr. Grove, has advised and counseled you. Are you satisfied with his representation?
Yes, I am.
Has he provided full, effective, and competent legal representation?
Yes, he has, Your Honor.
And Mr. Goodman, are you a citizen of the United States?
Yes, I am, Your Honor.
Mr. Goodman, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for defendant's plea of no contest in this case, the state is recommending confinement in a Jefferson County jail for a period of 5 days, Your Honor. We're asking that the court give defendant credit for the 5 days previously spent in jail, making this a time served plea agreement, Your Honor. We're asking that the court use the time served to both tax and retire the court costs, Your Honor. And lastly, this case will run concurrent with companion case number 324-644.
Mr. Goodman, the state is offering that you serve 5 days in Jefferson County Jail. However, you do not have to serve any more time in Jefferson County Jail because you've already served 5 days in Jefferson County Jail. Therefore, you'll be given credit for time served. The court cost in this case is $342, but you will not have to pay the $342 court cost because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. This case will run concurrent with cause number 324644. Mr. Goodman, do you understand the state's offer?
Yes, I do, Your Honor.
And do you think that the state's offer in your case is fair and just?
Yes, I do, Your Honor.
And do you accept the state's offer?
Yes, I do, Your Honor.
Mr. Goodman, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Goodman, your attorney has put before you a document that is titled Model Written Ammunition on Ineligibility to Possess Firearm or Ammunition. So in accordance with the Texas Administrative Code, Section 176.1, the court hereby admonishes you of the following. Number one, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013, a firearm means any device made or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are starting point for ineligibility to possess a firearm. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends that you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice of persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond, any family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective orders. Now, Mr. Goodman, that document that you have just been handed, you can keep that document for your records. Now, Mr. Goodman, this will conclude your case. You're going to stand on the X in front of the court coordinators and, the court clerk. And once you finish signing the judgment, you'll be free to go, and you have a blessed day.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome.
I just need his right thumb and number to swear.
Mr. Bailiff. It's Alan Santos.
And okay.
Okay. Thank you, Your Honor.
Okay, you're welcome. The court is in session. All right, same you have a blessed day as well. The court is in session in clause number 331662. Case is style of State of Texas versus Alan Santos or Alan William Santos. Mr. Santos, is that your full name? How are you doing, Mr. Santos? I'm doing fine. Thanks for asking. Hey, can we check to see if we have bond conditions in this case? Mr. Santos, you are represented in this case by attorney Terrence Allison. However, appearing for attorney Terrence Allison is attorney Marivius Allen. Does Mr. Allen have your permission to have your permission for him to stand in for Mr. Allison? Okay, and Mr. Marivius Allen is appearing via Zoom. Mr. Allen, how are you doing?
Good, how are you, Your Honor?
I'm doing fine. Mr. Allen, what is your announcement in Mr. Santos' case?
Yes, the defense would like to request one additional reset to schedule a conference to discuss the discovery with the state to determine the next state or next stage in this case.
Okay, how much time do you need?
Just a minimum reset, 4 weeks.
Okay, give us a reset date. He said, you get, what about 30 days? December,
The last week of November would be best.
okay. Okay, this case will be reset till November 30th of 2022. Mr. Santos, your attorney and your bondsman will be given notice of your resets. You're gonna be given a reset here in court. Once you get your reset, you'll be free to go. And Mr. Allen, your reset will be sent to you. This will conclude your case. You're free to go and you have a blessed day. And Mr. Santos, please stand on the X in front of our coordinator. Once you get your reset, you're free to go and you have a blessed day.
Thank you.
All right, you're welcome. Court is back in session. Next case is cause number 326-354. Case is styled the state of Texas versus Samantha Nicole Jones. Samantha Jones was scheduled to be in court this morning at 9 a.m. for the court's announcement docket. At or about 9 a.m., the court's bailiff called the name of Samantha Jones at the courthouse door, and Samantha Jones did not answer. Samantha Jones has not appeared in court since the court has been in session. The time now is 11:04 a.m. on today's date of October 26th of 2022. Mr. Bailiff, would you please call the name of Samantha Jones at the courthouse door?
Samantha Jones. Samantha Jones. No response.
Samantha Jones' name was just called again at the courthouse door. Samantha Jones did not answer. A reasonable time has passed to give Ms. Jones an opportunity to appear in court. If she has not appeared in court, State, do you have a motion?
Yes, Your Honor, they move for bond forfeiture.
That motion will be granted. Samantha Jones' bond will be forfeited and a warrant shall be issued for her arrest in cause number 326-354. Next case, or the next cases are cause number 329052 and cause number 329640. Both cases are styled the state of Texas versus Joel Espinoza. Joel Espinoza was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Joel Espinoza at the courthouse door. Joel Espinoza did not answer. Joel Espinoza has not appeared in court since the court has been in session. The time now is 11:05 a.m. on today's date of October 26th. Mr. Bailiff, would you please call the name of Joel Espinoza?
Joel Espinoza. Joel Espinoza. No response.
Joel Espinosa's name was just called again at the courthouse door by the court's bailiff. Joel Espinosa did not answer. A reasonable time has passed to give Mr. Espinosa an opportunity to appear in court. He has not appeared in court. State, do we have a plea bargain agreement? I mean, do we have a announcement, a motion in this case?
Yes, Your Honor, the state moved to bond over.
That motion will be granted. Joel Espinosa bond will be forfeited and a warrant shall be issued for his arrest in cause numbers 329-052 and cause number 329-640. Next case is cause number 330-206. Case is styled the state of Texas versus Andre M. Rodriguez. Mr. Rodriguez, would you please come forward? Good morning, Mr. Rodriguez. Your full name is that Andre M. Rodriguez?
Yes, sir.
How you doing, Mr. Rodriguez? That's good. Now, Mr. Rodriguez, you're represented in your case by your attorney Todd LeBlanc. Please check to see if we have bond conditions in this case. And Mr. LeBlanc has not appeared in court today. Have you been in contact with your attorney?
No, sir.
Okay, the court has attempted to make contact. He has not responded. So therefore, Mr. Rodriguez, first of all, we're sorry for your inconvenience. Next, this case is going to be reset. Are you working?
Yeah.
Okay, give him a maybe just so that it would not interfere with your job. We're going to reset it for about 60 days. Okay, that's fine.
I have a question, is this case gonna interfere with me taking the flight? Or-
Oh, you talk to your bondsman.
Okay.
Yeah,
He doesn't.
Hmm? He doesn't. I need some bond conditions. Give me that blue tablet. Thank you. Ms. Linda, would you please make me a copy of this? I need to get a copy to Mr. Rodriguez. Now, Mr. Rodriguez, the court is going to give you some standard bond conditions in your case. And I will go over the standard bond conditions with you. And it reads, following arrest and or accusation in county court at law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall not commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? The defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, refuse or submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 doesn't apply because that only applies in a DWI case. Your case is not a DWI case. Now, Mr. Rodriguez, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, warrant will be issued for your arrest, and you'll be placed in the Jefferson County Jail. Do you understand that? Mr. Rodriguez, I'm going to give you a copy of these bond conditions. Mr. Bailey, will you please hand these bond conditions to Mr. Rodriguez? And Mr. Rodriguez, your case is going to be reset for 60 days. Mr. Rodriguez, please stand on the 4X in front of our court coordinator. Once your case is reset, you're free to go and you have a blessed day. Again, thanks for being patient. And this will conclude the calling of the court's announcement docket.
Ron Batista called and said his client was having complications on the way.
Oh, this is Ms. Carrazzo?
Yeah, she had the last one.
Oh, that person is in jail. Okay,
I think that person was supposed to be 257.
okay, all right. Okay, Ms. Carrazzo, you having some difficulties with your Zoom. You may have to Zoom back in. We can't hardly hear you. You're gonna call on the phone?
Is that better?
Oh, you a lot better. 100%.
Okay, good.
Okay, Miss, this is cause number 332-912, case of style of state of Texas versus Brian Keith Roach. Mr. Roach actually has a felony case that's set today. Now, in his misdemeanor case, Mr. Roach is represented by attorney Laura Perrazzo, who's appearing via Zoom. Attorney Perrazzo, how are you doing?
I'm doing well, Your Honor. Thank you.
That's good. Ms. Perrazzo, Mr. Roach has a felony case that's set today, that was set today in the 252nd District Court. Was there a disposition on that case? Have you, our court coordinator just checked with to see the disposition of the case, the felony case, and as of now, there's nothing in the computer. So that case was set for an announcement plea today. Ms. Perrazzo, do you want this misdemeanor case to be set with the felony case if the felony case is reset to another date? Ms. Perrazzo? No. It froze up. Oh, there she is.
I apologize. I don't know what happened.
Okay, that's all right. Now, Ms. Perrazzo, Mr. Roach has a felony case set today in the 252nd District Court. Our court coordinator and the clerk checked, and they do not see that this case has been reset or whether or not they have not been able to determine or see if there's been a disposition on this case.
Okay.
Now, if this case is disposed of today, would you like to have this case reset on our jail run docket tomorrow?
No, sir. I will actually be in trial in the 88th district in the morning,
Okay.
starting at 10.
So if it's disposed of today, we can set it on our next jail run, not the one tomorrow, but the one after that, which it will be
Okay.
next Thursday. Now, if they just reset it on a different date, we can just set it on the same date that they set the felony case on.
Okay,
Okay, so what we have to do is check the court's disposition or reset, and then we'll set it accordingly.
okay, that sounds great.
All right, and then we'll send you the reset. All right,
Okay, thank you
All right.
very much.
you're welcome. You're free to go and you have a blessed day.
You too. Bye-bye.
Okay, now, they received a call from, Ryan Matuska's office stating that Samantha Jones was having some, car trouble and she's on her way. And so,